Okay, testing.
Keep going, keep going.
Can you hear me? Testing.
Yeah, that's a good check. So that's what happened.
Okay.
Mic check, 1, 2, 3. Testing, testing. Good morning, everyone. We'll be getting started here shortly. As a kind reminder, if you are registered to speak and it is your turn to come to the podium, before you speak, please make sure that this light is on the microphone. If it is not on, simply push the button, the light will pop on. And before you leave the podium, so that you're not heard saying any extra comments for time, make sure that you mute the microphone before you leave the podium, as I'm about to do right now. Test 1, 2.
Good test.
and welcome to the March 13th, 2025 meeting of the Texas Commission on Environmental Quality. It is 3:29 a.m. Apologies for the tardiness. I'm joined by my colleagues, Bobby Janeka and Katarina Gonzalez, our General Counsel, Mary Smith, and our Public Interest Counsel, Garrett Arthur. For each item that argument or discussion is allowed, we will inform parties and the public of time limits for their discussion. Registration closed at 9:30. But if you would like to address the commission on a particular item, please either visit our registration table if you're here in person, or if you're on the webinar, email agenda@tcq.texas.gov with your name, affiliation, and the item you would like to comment on. We will do our best to accommodate the request. For those making presentations, please wait to begin your presentation until I have asked you to begin speaking. And please check to make sure that your line is unmuted before proceeding. Ms. Smith, call the first item.
I believe we're going to take some items out of order and begin with item 3 because we understand that there was a family emergency and that some folks signed in on that item need to get back on the road. Item 3 is consideration of the application by the Oasis of Texas LP for new Texas Pollution Discharge Elimination System Permit number WQ 00164-36001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Commissioners, are you okay taking these out of order?
Yes.
Yes. Excellent. Well, this is a hearing request matter involving an application for a permit to authorize the discharge of treated domestic wastewater at a volume not to exceed 50,000 gallons per day. Hearing request matters involve a two-step process. First, we determine if any hearing requesters are potentially affected in a manner different than the general public and met the procedural requirements of the statute. If any of the hearing requesters meet this requirement, we then evaluate what relevant and material issues were raised in those hearing requests for a referral to SOA. Let's talk about effectiveness. Beginning with the hearing requesters, I would refer Mr. Robert Miller for a contested case hearing. Mr. Miller's property neighbors, the proposed facility and the discharge route flows through his property. He timely filed a hearing request and raised relevant and material issues on those requests. I would deny the remaining requests. At over 100 miles from discharge, Ms. Grindstaff did not explain how she would be affected by the authorization in a manner different than the general public. Ms. Evans' hearing request did not raise any issues, and Mr. Jerry Clark did not file a timely hearing request. Colleagues, what do you think?
I'm in agreement.
Katarina?
I'm also in agreement.
Excellent. Let's talk about the issues. As far as the issues are concerned, I identified 2 relevant and material issues from Mr. Miller's filings. In my view, he raised concerns about the characterization and adequate operation of the discharge route, as well as concerns related to water quality generally. Bobby, Katarina?
This captured what I found.
I'm also in
Yes.
agreement.
Thank you. I would also refer this matter to our ADR program and allow 180 days for hearing. Do I have a motion?
I move that we grant the hearing request to Robert Miller, deny all remaining hearing requests, refer the application to SOA for a contested case hearing on the following issues. Issue 1, whether the proposed discharge route is properly characterized in the application and will function properly as an operational feature of the facility. And issue 2, whether the draft permit is protective of water quality in accordance with the Texas Surface Water Quality Standards, 30 Texas Administrative Code, Chapter 307. I further move that we refer the matter to the TCQ's Alternative Dispute Resolution Program concurrently with the SOA preliminary hearing process and set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
Second?
All those in favor say aye.
Aye.
Aye. Motion passes. Excellent. Well, we will hop right on back to item 1.
Would you like to take 4? We have some a legislative member and Railroad Commissioner Wright.
Absolutely. Important people are here. Item 4, please.
Item 4 is the consideration of the application by the city of Corpus Christi for new TPDES permit number WQ000528900. The parties have been notified that the commissioners will not take oral argument, but may ask questions. And I would like to just acknowledge that there are a great deal of the people in the audience here today are signed in on this item. And we appreciate their presence here.
Yes, welcome to Austin, y'all.
As a courtesy to the members of legislature and to statewide elected officials, the commission allows legislative members and statewide elected officials to address the commission. We also allow staff members to read a legislator's remarks to the commission. And so I understand that we have somebody from each of those categories here. And if you'd like, we can begin with Railroad Commissioner Wright.
Green button. Good morning, Commissioner.
Good morning, Madam Chair, Commissioners. Thank you guys for allowing me to say some words here. You know, as a politician, I can't pass up that opportunity ever, right? You know, I'm here today, not necessarily on the behalf of the Railroad Commission of Texas, but more on the behalf of being a person who is born and raised in Corpus Christi area's community. And to talk about and stress the need that it's important for us to really seek and find additional water sources than those that we've kind of relied on in our past, which has been rainfall, which I don't know if you guys are aware, but we haven't had much of that lately. In fact, I've never seen a longer period without the rain that's needed in my history or in my lifetime. So I want to stress to you that being from that community and seeing the great improvements they've made, not just in what they provide their residents, but what they've done from an industrial growth side, that finding these new water sources and improving these new water sources are important for that community. Their reliance on what their success has been is all based on water. And as everybody knows, if you don't have water, you really can't survive. So I appreciate the opportunity to speak about that today and stress the importance of any water sources such as the one you're considering today. So I appreciate you allowing me to say a few words about that.
No, we appreciate your words. Thank you so much. All right, who else do we have?
We have Representative Villalobos.
Good morning, Representative.
Good morning. It's very nice to meet y'all.
Nice to meet you too. Thank you for coming.
Yeah, thank you. So I'm Denise Villalobos, representative for Texas House District 34. I am proud to tell you that our region is an economic driver, not only for the coastal bend, the state of Texas, but the nation. We have a large, a large amount of industrial users in our area that have gone above and beyond in producing efficiencies in their water usage for the past 2.5 years as we combat this drought. Corpus Christi is looking to become on stage 4 drought here in August. We can no longer rely on surface water, as Commissioner Wright was saying. This is not drought-proof infrastructure that we currently have, and our economies heavily rely on it. Billions of dollars, I believe the number was about 3.6, 3.9 billion a month comes out of the Corpus Christi economy for the nation, the state of Texas. I am a chemical engineer by degree. I work at a local refinery, and we provide jet fuel to American Airlines in DFW, to American Airlines here in Austin. If our industry goes down, if we do not have the water that's needed, those planes stop flying. We have refiners in our community that provide the gasoline that got you here today. We have LNG plants in our community that provide power to Europe out of Corpus Christi, Texas. We are in great, desperate need for a new water source. Right now, I will even add the fact that Owen Stevens, the one singular water source facility that we do have, is singular. There is zero redundancy. If anything were to happen to that today, everything is offline, and that's unacceptable. This desalination facility, Inner Harbor facility, would allow a second redundant source. I urge this commission to adopt all of the executive director's recommendations. We need to streamline approval for the final permit and for future of water in South Texas. Thank you so much.
The green light. Got to remember the green light. Thank you.
And then we have Mr. Miguel Rivera for, to read a letter from Senator Hinojosa.
Good morning, Chairwoman, Commissioners, and Council. My name is Miguel Rivera, and I'm writing a letter on behalf of Senator Juan Chuy Hinojosa. This was dated March 12th, 2025. Dear Chairwoman Pop, this letter is submitted to you in support of the City of Corpus Christi's Inner Harbor Seawater Desalination Project. Discharge, I think it's agenda item number 4. Timely approval of this discharge permit is important for advancing the Inner Harbor project, which is a key component of the city's long-term strategy to secure additional water sources in our drought-prone region. As the regional water supplier for over 500,000 residents, businesses, and major industries in the 7-county coastal bend area, Corpus Christi's water supply is heavily reliant on surface water sources that are increasingly stressed by drought and growing demand. During this legislative session, the state of Texas is working to fund and promote the development of new alternative water supply to add security and resiliency along with economic prosperity. Over the past 5 years, the city has diligently pursued this discharge permit through the TCEQ process, collaborating with agency staff to ensure all environmental protection measures are met. The city's plan, developed a decade ago, was a collaborative effort of local leaders, major water customers, and economic development representatives. It has progressed through each phase from feasibility to project profiling, site evaluation, environmental and water analysis, costing, financing, permitting, and contractor selection. The city's project is a balance of environmental responsibility, feasibility, and affordability for such a significant investment. Key facts regarding the status of the project include all major permits have been submitted to the state and federal agencies and have been secured or are in process. As part of these permits, extensive environmental assessments have been completed. And after review of the Inner Harbor project, the EPA sent a letter of no objection on the Inner Harbor discharge permit in 2024. And the executive director of the TCEQ has recommended that the commission authorize the discharge permit at the March 13th, 2025 meeting, saying the permit, if issued, meets all statutory and regulatory requirements. And the TCEQ permit for the Inner Harbor water rights was approved in 2022. And permit applications submitted to U.S. Army Corps of Engineers are nearing final approval in spring 2025. I support the city's Inner Harbor Seawater Desalination Project, as it is the drought-proof water supply project closest to the completion in our region. As water levels in the Nueces River Reservoir decline, further delays could have significant economic development consequences for our state. TCEQ's approval of this project would help us combat the ongoing drought conditions and provide water for our future. I respectfully request your assistance in expediting the approvals of all remaining permits and conditions to facilitate timely and cost-effective delivery of this project for our ratepayers. Signed sincerely, Juan Chuy Hinojosa.
Thank you for reading that, and please tell your boss I said hi.
Will do. Thank you, Chairwoman.
And I'd just like to take a moment to remind the commission that your decision today should be based on the timely comments, the hearing requests, the request for reconsideration, the response to comments, application, draft permit, essentially the administrative record that's before you today.
Absolutely. All right. Before us, we have an application by the City of Corpus Christi for a new TPDES permit for the Corpus Christi Inner Harbor Desalination Plant. The facility will produce 20 million gallons per day of potable water in the initial phase and will increase to 30 million gallons per day in the final phase. The draft permit proposes to authorize the discharge of water treatment waste of up to 51.5 million gallons per day once the project reaches its final phase. In response to EPA's review of the draft permit, the ED incorporated revisions including a salinity monitoring requirement narrative salinity criteria, and implementation of salinity monitoring requirements. The draft permit also includes a requirement that within 90 days of the initial discharge, the city shall submit to TCEQ the results of its analytical testing of conventional and non-conventional constituents, metals, and toxic pollutants. Based on a technical review of the submitted analytical results, TCEQ may reopen the draft permit to include additional effluent limitations, monitoring, or both. For these types of applications, the commission considers a two-step analysis to first determine whether a hearing requester is an affected person, and second, whether an affected person raised an issue in their hearing request that is referable to SOA. So let's talk again about affectedness. The commission received timely hearing requests from numerous individuals in two groups, specifically the Hillcrest Residents Association and the Texas Campaign for the Environment. I'll begin with my thoughts on affectedness. To be considered an affected person, a requester must explain how they will be affected by the application in a way that is not common to members of the general public. The hearing requester must also file both timely comments in a hearing request that identify both their personal interest and the concerns they have. Finally, the identified concerns must be within the commission's jurisdiction to address in the authorization. For the groups and associations, there are additional requirements for the commission to review. Most relevant for today's analysis, to be entitled to a hearing, a group or association must identify a group member that has standing to request a hearing in their own right. Looking at the group hearing requesters first, I believe Hillcrest Residents Association's hearing request should be denied. While the group filed a timely comment in a hearing request, I do not believe that the members' interests sufficiently distinguish their activities from those of the general public, such as they would to confer standing. Therefore, I would deny their request. Next, I do not believe the Texas Campaign for the Environment has met the associational standing requirements for effectiveness, as they failed to identify a member who would otherwise have standing to request a hearing in their own right. Colleagues?
Could I get Commissioner Gonzalez's thoughts before I weigh in?
Yes, I've looked at all the hearing requests in this matter, and I do not believe that any of the hearing requesters met the requirements to be affected persons. We reviewed each one carefully, including Hillcrest Residents Association's hearing request, and I do not think that any of their members demonstrated that they would have standing to request a hearing in their own right. Given the nature of the discharge and the distance from the facility and its outfall to the members' activities, I think the interests that they raise are too attenuated to show that they would be affected in a manner different from the general public. When looking at the factors set out by statute, such as the nature of the distance of the discharge from the interest claim, the likely impact of the regulated activity on the health and safety of the person, and on the use of the property of the person, likely impact of the regulated activity on use of the impacted natural resources by the person, I could not find that the requesters crossed the threshold to meet the definition of affected persons. Staff also performed Tier 1 and Tier 2 anti-degradation reviews and preliminary determined that existing water quality uses will not be impaired by this permit action and that no significant degradation of water quality is expected in Corpus Christi Inner Harbor, which has been identified as having intermediate aquatic life uses. Thus, I believe that existing uses will be maintained and protected. I agree with the ED's analysis and conclusion that HRA's hearing request fails to identify members who would have standing in their own right in accordance with 30 TAC 55.205. I also think that it's important the city is pursuing this project and taking the steps necessary to provide the area with much needed water. As Senator Perry has said many times, we must consider all options available for water supply strategies in the state. And I think desalination is an important step in this plan for the future water supply of Texas. I would also recommend denying all the requests for reconsideration, as I do not believe they raise new relevant and material information for the commission to consider. I think the ED's RTC adequately addresses all the issues that these requests have raised. So therefore, I would recommend denying all hearing requests and requests for reconsideration, issuing the draft permit as recommended by the executive director, and adopting the ED's response to comments.
Thank you, Katarina. Bobby?
I appreciate that. I appreciate both of you weighing in, and I'm in agreement, and I'm prepared to vote with y'all today.
Well, let's turn to the individual hearing requests in this matter. I did not find any of them satisfy the requirement to be determined affected persons. These requesters either failed to say how they would be affected differently than the general public, failed to raise any specific issue, or raised issues like light pollution or noise that are beyond the commission's jurisdiction to address this in this proposed discharge permit. Katarina and Bobby, in agreement?
Yes.
I am.
Well, I have a motion. I move that we, 1, deny all hearing requests and requests for reconsideration, 2, adopt the ED's response to comments, and 3, issue the draft permit as recommended by the executive director.
You're supposed to be protecting the environment. You're going to kill Corpus Christi Bay, put people's health and livelihoods at risk by killing the fishing industry, the tourism industry, and it's on your hands. We're not going to tolerate it, and we will fight this.
Do I have a
I
second?
second the motion. Yes, second the motion.
All those in favor say aye.
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 The motion passes. Thank you. I'll give everyone a moment to clear out. All right, we're going to head back to item number 1.
Item number 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the application of Corpus Christi Liquefaction LLC for amendment of air quality permit numbers 105710 and PSD TX 1306 M1, and the voluntary update of permit number GHG PSD TX 123 M1. The applicant should present first, followed by the protestants, the ED and OPIC in that order. Applicants, protestants collectively, the ED and OPIC will each have 5 minutes of oral argument time, and the applicant may save time for rebuttal as it bears the burden of proof on this application. And so we'll begin with the applicant.
Good morning. Can we close the door, please?
Good morning,
Good morning.
Chairwoman Pop, Commissioner Janeca, Commissioner Gonzalez, General Counsel Smith. My name is Whit Swift. My co-counsel Kevin Collins and I are with the Bracewell Law Firm, and we're here representing the applicant Corpus Christi Liquefaction LLC. Corpus Christi Liquefaction didn't get called out by name, but you heard us referenced in the discussion of the desal item there in item number 4 as one of the vital Corpus Christi area industrial users of water and other resources. 2 company representatives from Corpus Christi Liquefaction, or CCL, as I'll call them, are here today, Megan Maston and Craig Kondoff, and there are others participating in the meeting virtually. CCL appreciates the work of the Air Permits Division in putting together the draft permit in this matter. We also appreciate the work of the Chief Clerk's Office, the Environmental Law Division, and the Office of Public Interest Counsel in processing this contested case hearing that led to the proposal for decision that's before you today. CCL filed this pending application to authorize a change at its existing Corpus Christi liquefaction terminal to increase flaring emissions there at the terminal under permit number 105710, which authorizes an area of the terminal known as stages 1 and 2. The amendment only seeks to authorize emissions from those flares, and the disputed issues in this hearing were limited. After evaluating the evidence in the record, the ALJs found, with respect to the disputed issues, first, that the draft permit's operating and work practice requirements for the flares satisfied best available control technology, or BACT requirements, for flares in similar service. Second, that the emissions calculations from the flares, which were based on TCEQ guidance and reliable test data and derived from that test data in a reasonable way, satisfied applicable requirements. Third, that the monitoring and record keeping provisions that apply to the flares, which go beyond the requirements in any other LNG terminal permit here in Texas, satisfy requirements and will assure compliance with permit limits. And last, that the permits limits themselves, specifically the carbon monoxide limit that applies to the flares, is enforceable, and that the permit monitoring, record keeping, and reporting requirements will ensure that CCL complies with the emission limits and the emission limit increases that are authorized in the draft permit. The ALJ's recommended issuance of the draft permit with one small change to the permit in the flare monitoring provisions to make 2 terms consistent. No parties to the hearing objected to that change. The proposal for decision found that the applicant met its burden of proof on all items sent to SOA and recommended issuance of the draft permit. The applicant supports the PFD, finds that it's well-reasoned, and supports the proposed order received from the SOA judges. And as you know, no party filed any exceptions to the PFD or proposed order. For that reason, the applicant respectfully requests that you issue an order that adopts the executive director's response to comments and issues the draft permit with the limited change identified in the proposed order to make the monitoring provisions consistent. Thank you very much. I'll answer any questions that you have for the applicant at this time. Otherwise, I will reserve the rest of my time for any rebuttal.
Thank you. Thank you, Mr. Smith. We'll hear from the protestants, please.
No one for the protestants is registered, so, and I see nobody get up.
Give them 1 minute. All right, we will hear from the executive director.
Good morning. My name is Contessa Gay with the Environmental Law Division, here representing the Executive Director. With me and available to answer questions is Christopher Loughran of the Air Permits Division. Available online is Amanda Krennock with the Environmental Law Division, and Sarah Hill, also with the Air Permits Division. As mentioned, this authorization, if issued, will authorize Corpus Christi Liquefaction to modify the existing permitted natural gas liquefaction and export terminal. The Executive Director agrees with the ALJ's recommendation that the Commission should issue the permit to Corpus Christi Liquefaction with the change to Special Condition 14. The executive director maintains her position that the review of the application and draft permit met all applicable statutory and regulatory requirements. The executive director's staff performed the necessary review to ensure the draft permit would meet all federal and state requirements and would be protective of the environment, human health, and welfare. Thank you, and we're available to answer any questions.
Excellent. Thank you so much. And next, we will hear from OPIC.
Thank you, Chairwoman. Good morning to you and the Commissioners, General Counsel, ED attorneys, and staff. For the record, I'm Josiah Mercer with the Office of Public Interest Counsel. We participated in the hearing, evaluated the evidence and arguments presented, and concluded that a preponderance of the evidence in the record shows that the draft permit with the changes recommended by the proposal for decision complies with applicable statutory and regulatory requirements on the issues referred to hearing by the Commission. With specific regard to the facility's use of flares, although OPIC maintains its concerns that the methodologies used to estimate volatile organic chemicals and nitrogen oxide emissions are based on potentially outdated TCEQ guidance, we cannot say that their use was improper. Similarly, we agree with the administrative law judge that the emissions calculations methodologies used to calculate particulate matter emissions are longstanding TCEQ practice and are adequate to satisfy the rules. We therefore agree with the ALJ that the preponderance of the evidence shows that the flares will achieve the performance specified in the draft permit. Testimony from applicants' witnesses sufficiently addressed Dr. Sahu's concerns about the prevention of significant deterioration process and the October 2022 application revision. We appreciate the clarity provided by the ED's closing about the 625 pounds per hour per train gas flow rate representation being an average rather than a hard limit. We also agree that protestants did not present evidence that the best available control technology requirement was violated sufficient to rebut the presumption created by the prima facie demonstration. Finally, we agree with the proposed change to Special Condition 14E to require a continuous composition analyzer in both potential monitoring scenarios. The applicant relied on that representation that a composition analyzer would be used, and the applicant supports incorporation of that requirement, as we just heard. As such, OPIC agrees that this representation should be made enforceable and should be reflected in the permit. With that change, the draft permit's special conditions are adequate to achieve the permit conditions. For these reasons, we find that Corpus Christi Liquefaction has met its burden of proof with respect to each of the issues referred, and the ALJ's PFD, with its recommended change to the special conditions, should be adopted. Thank you, and I'm available to answer any questions.
Thank you, Josiah. Mr. Swift, you have 1 minute and 20 seconds left for a rebuttal. Not sure what you're rebutting right now, but
First, no rebuttal from the applicant. Thank you.
thank you. All right, well, I will keep this short and sweet. Thanks to everyone for your presentations. Colleagues, I've reviewed the record and the ALJ's PFD and the proposed order and agree with the ALJ's recommended order, other than a few clerical edits, which I can set out in a motion. I am ready to adopt the proposed order and the ED's response to the comments, as well as to issue the permits. Thoughts?
I'm in support of that, and I would second that motion.
I'm in agreement.
Do I have a motion?
I move that we adopt the ALJ's proposed order with the following changes. A, revise the SOA docket number and the title of the order to reflect the correct docket number 582-24-14373, and that we amend the finding of fact number 3 to reflect the correct PSD permit number, PSD TX 1306M1, and that we issue the ED's draft permit and adopt the ED's response to comments.
I second the motion.
All those in favor say aye.
Aye.
Aye. The motion passes. Thank y'all very much. Give everyone a minute. All right, Mary. Everyone is settled. All right, let's go to item number 2, please.
Item number 2 is the consideration of the ALJ's proposal for decision and proposed order concerning the application by Megatel Homes LLC for new TPDES permit number 00161-62001. The parties have been notified that the applicant, the protestant, the ED, and OPIC will each have 5 minutes of oral argument time. The order of presentation will be applicant, protestant, ED, and then OPIC. The applicant should speak first and may reserve a portion of time for rebuttal as the applicant bears the burden of proof in this matter. And I believe we have Mr. Seal here for the applicant.
Madam Chair, Commissioners, and General Counsel. For the record, I'm Derek Seal. I'm with the law firm of McGinnis Lockridge here in Austin. I represent the applicant, Megatel Homes LLC. This is a pretty simple case. The only issue that's before you today is whether our application meets the state's regionalization policy. The administrative law judge's proposal for decision fully explains why and how our application is entirely consistent with that policy. Only the city of Mansfield has opposed our application. The long and the short of it is that our good faith negotiations with the city over several years resulted in a development agreement which would have provided for wastewater service for our 517 acre development. City staff recommended that the city council approve that development agreement, which included wastewater service 3 times. The city council refused to act 3 times. The precedent for the regionalization policy, and most of this comes from the Crystal Clear case that's cited in the briefing, is that refusal to provide service is in effect denial of service. When the city council refused to approve the development agreement, the city denied service. That's all that your regionalization policy requires. That's the end of the inquiry. There are several other reasons why that are explained in the briefing and in the PFD why we meet the regionalization policy. I won't go into those in the interest of time, but we do respectfully request that the commission adopt the ALJ's proposal for decision with the minor modifications from the ALJ's January 9 letter, that you adopt the response to comments, approve the application, and grant the permit. I'm happy to answer any questions you may have now, but I would like to save the remainder of my time for rebuttal.
All right, thank you, Mr. Seal. We'll hear for the protestants. Good morning.
I should have put on my readers this morning. My apologies. May I proceed?
Do you need them?
No.
Okay.
I found it. I found the button. May I proceed?
Absolutely.
Yeah, thank you. Madam Chair, Commissioners, General Counsel, my name is Art Rodriguez. I'm with the law firm of Messer Ford. We represent the city of Mansfield specifically in this case, and many other municipalities across the state that have seen the same type of regionalization issue come up with utilities in their community. I do want to begin by saying this is my first time at this location. I've spoken in front of y'all in front of the at your old location. I like this one better, being a little bit offset here because that rear camera doesn't quite get my bald spot that's coming in. So I appreciate that very much. Notes for the future. City of Mansfield did protest the application, and as you know, there many issues were referred, and MSJ was filed on many of them, with the only issue being regionalization. And the going through the regionalization guidelines in this, I think, is particularly important for the commission to take a look at what your guidelines are and what it is that we're really trying to accomplish through those guidelines. Guidelines and the statutory requirements in this case are that the PUC take a look at regionalization, so there's not a proliferation of point sources of pollution along Texas's rivers in order to keep water clean for everyone, not only for enjoyment, but also for drinking water purposes. In this case, what is troublesome is that in the very first guideline asks for whether there's collection systems within 3 miles of the plant, the proposed plant, which the applicant indicated there was not. And there clearly is, the evidence is clear and uncontroverted in the record that the city does have collection system lines within 2.5 miles of the proposed facility. And this type of misrepresentation in application should not be rewarded by having the permits actually issued in this case. Likewise, the request for service has never been denied by the city. The city is open and available to provide service to the applicant. Have terms of service actually been met at this case? No, the answer is no to that, obviously, but that does not mean that the city is not willing and able to try to come to some agreement with the applicant, and the applicant just has not had that opportunity to come up. The applicant and the city haven't had that chance to come to final agreement on those terms. The other two issues that are guidelines that the commission have are absolutely irrelevant in this case. What I'd like to stress is that regionalization is stated in statute of the water code many times, and particularly with respect to TPDES permits twice in the code, as well as there's several bills that have been filed this session to actually strengthen and actually provide a lot more guidance to prevent these exact type of small plants from being additional point sources of pollution in the area. I respectfully request that the commission deny the application. We provided exceptions to the PFD with proposed language changes to the order, and we request adoption of what we submitted. I stand available for any questions that you might have.
Thank you, Mr. Rodriguez. We will hear from the ED, please.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. I'm Allie Swallow with the Environmental Law Division, and with me today is Deba Dutta with the Water Quality Division. The Executive Director supports the administrative law judge's conclusion in the two referred issues. The ALJ found that the applicant complied with TCEQ's regionalization policy. Can you hear me?
Oh, is your mic on? Are you sure it's on?
Yeah, it's on, but I was far away from it. Let me move it closer.
We're all having mic issues today.
Okay, let's see. Is this better?
Yeah, Commissioner Gonzalez, can you hear the ED?
I can, yes.
Okay, good.
Okay, good.
Thank you.
Okay. The ALJ found that the applicant complied with TCEQ's regionalization policy and that the draft permit is protective of water quality in accordance with applicable Texas water quality standards. Therefore, in the absence of evidence that the draft permit violates a specifically applicable state or federal requirement, the ALJ recommended that the commission issue the draft permit and adopt all findings of fact and conclusions of law contained in the proposed order. She issued some changes in her letter on January 9th, but they were minor. The executive director agrees with the ALJ and respectfully recommends that the commissioners adopt the ALJ's findings of fact and conclusions of law, grant the application, and issue the draft permit. Thank you, and we're available for questions.
Thank you. Any questions? All right, we will hear from OPEC. Jessica?
Good morning.
Good morning.
Chairwoman, Commissioners, Executive Directors, Attorney, and staff. For the record, I'm Jessica Anderson with the Office of Public Interest Counsel. We participated in the hearing, evaluated the evidence and arguments presented, and concluded that, in agreement with the proposal for decision, the applicant has met its burden of proof on the referred issues. Therefore, OPIC supports adoption of the PFD and recommends that the application be granted. The weight of the evidence demonstrates that the applicant has met its burden with respect to regionalization. Protestant argued that the applicant failed to meet its burden regarding regionalization because it failed to fully explore the possibility of obtaining service from either the City of Mansfield or the Trinity River Authority of Texas, TRA. The ALJ found this argument unpersuasive, and OPIC agrees. During the application process, representatives of the applicant and the city reached a development agreement which conditioned wastewater service on annexation, under which the city would provide wastewater services to the applicant. Subsequently, this development agreement was not adopted by the city. By not adopting the development agreement, the city indicated that it would not provide service to the applicant. The applicant did discuss wastewater services with the city, and those discussions did not lead to the city agreeing to provide wastewater service. As articulated in the PFD, once the city did not agree, the inquiry into regionalization stops. Protestant also argued that the applicant failed to request wastewater service from TRA. The city has a contract with TRA under which the city collects and transports all wastewater in its designated service area to TRA for treatment. This contract provides that only the city may collect and transport wastewater in the designated service area. Applicant's proposed development is located within this service area. TRA is not a designated regional provider, has not provided service directly to developers instead of to its city participants, and appears to be contractually forbidden from providing service in the designated area. OPIC is in agreement with the ALJ's finding that the applicant's failure to contact TRA should not be the basis for denying the application or altering the terms of the draft permit. For these reasons, we believe that the applicant has met its burden of proof with respect to the referred issues, and therefore the ALJ's proposal for decision should be adopted. Thank you, and we are available for any questions.
Thank you very much, Jessica. Any questions? Nope. Mr. Steele, you have 3 minutes and 12 seconds exactly for your rebuttal.
I will try not to use all of that time, Madam Chair. I do want to respond to a couple of the issues that Mr. Rodriguez had raised. First and foremost, his statement about the regionalization policy is to prevent the proliferation of smaller package plants in the interest of water quality. I would point out to you that the draft permit does meet TCEQ's water quality standards in Chapter 307. That means the permit is protective of water quality, regardless of whether the regionalization policy has how it shakes out. So the draft permit is protective of water quality. There's not a water quality issue here. The record does not indicate otherwise. With regard to the collection system within 3 miles, we didn't check the box in the application that said the city had some pipes within 3 miles, but I do want to read from the PFD on page 19 how the ALJ considered this. And she said, certainly Megatel did not indicate in its application there were city pipes approximately 2.4 miles away. There is no suggestion this omission was intentional. However, to the contrary, shortly before the application was filed, the city's own engineer had emailed the applicant that Cipriani development was very far away from any water or sewer infrastructure. Regardless, that check box was harmless error because we did try to negotiate an agreement with the city. With regard to whether service was denied, make no mistake, service was denied. Megatel is not required to negotiate indefinitely with the city. We negotiated for well over 2 years. And I thought it was, this morning, I actually Googled the definition of denial this morning, and Merriam-Webster defines denial as refusal, an unwillingness to grant something asked for. That's what happened here. This application was denied. The last thing I would like to respond to is, there may be some bills pending in the legislature. None of those apply to this application. I would submit to you that we did everything we were required to do under TCEQ's rules and policies, and that the application should be approved.
Thank you very much, Mr. Steele. Any questions? All right, well, thank y'all for your presentations. I've reviewed the ALJ's proposed order as well as the administrative record and believe that they support the ALJ's recommendation determinations and that the applicant has demonstrated need and that the agency's policy on regionalization was appropriately evaluated. I also agree with the various minor amendments proposed by the applicant and its exceptions, which the ALJ agreed to. I believe that it would be helpful to add some additional information from the record to the findings of fact to better explain and support the conclusions of law. I've also identified some minor clerical revisions. Colleagues, if you are generally in agreement that this permit should be issued, I would propose that I make a motion with the changes I just alluded to, and we can discuss the details on the other side. How does that sound?
No objections here.
Katarina?
No objection. All good.
I move that we, one, adopt the administrative law judge's proposed order as modified by the applicant's exceptions and recommended by the administrative law judge in her letter dated January 9th, 2025, with the following additional modifications. In finding of fact 32, clarify the dates when the city council considered the development agreement so that it states the development agreement was on the city council agenda during the January 22nd, 2024, February 12th, 2024, and April 8th, 2024 city council meetings, but the city council did not adopt the development agreement during any of those meetings. In finding of fact 33, clarify the method by which the city did not agree to provide service so that it states the city indicated it would not provide wastewater service when it did not adopt the development agreement. In ordering provision 1, replace the 3 in the permit with the number 2. And in ordering provision number 2, replace 50 cents with 25 cents regarding transcription costs. Number 2, adopt the ED's draft permit. Issue the ED's draft permit. And number 3, adopt the ED's response to comments. Colleagues?
I second that motion, and I just proudly point out and endorse the fact that our chairwoman is catching every quarter in our agency's responsibility here for our legislatures. They're considering budget decisions for us, so thank you.
Thank you, Bobby. Katarina?
I'm ready to vote.
Do I have a motion? Oh, to get, you
Made and
second.
seconded.
All those in favor say aye.
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 This is a little rough when I've got Katarina up there. I can see ya. All right, we've done 3 and 4, so let's go to 5, please. Thank y'all very much.
And I'm going to give the ED staff a moment to get in up to the table.
Garrett, you seem lonely. All right, Mary, let's do item number 5, please.
I think we need the ED staff. I'm not sure if
Do we
they're
have ED staff?
planning to present virtually or if they're stuck in the hallway on the way into the room.
We will pause for a second to find our ED staff.
Give a moment to sort that out and maybe skip to the enforcement docket as I see the staff members are here for those items. And those items are 7 through 9 and 11 through 22. Item 10 was remanded at the request of the executive director on March 11th. And the executive, will give everybody a chance to get situated, but then the executive director's staff is here to present these matters.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Amy Sedemeyer of the Enforcement Division, and with me today are Craig Pritzloff of the Office of Compliance and Enforcement and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 7 through 9 and 11 through 22. The total assessed administrative penalties are $276,046, with $54,057 deferred, $90,050 applied towards supplemental environmental projects, and $131,939 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you very much. Any questions? All right, has anyone signed on this item?
So on items 16 and 21, we have individuals signed in and they indicate that they don't want to address the commission, but they're available if the commission has questions. And on number 11, we have Stephen Stone signed in. I believe he's virtual.
Mr. Stone, are you available for comment?
You may need to turn the volume down on wherever you're listening to us at the moment, Mr. Stone.
Mr. Stone, are you ready to speak?
I don't know. 3 months.
Mr. Stone, we can hear you.
Oh, I'm so sorry.
That's all right. You're here to comment on number 11?
Yes, ma'am.
Go right ahead.
Oh, shoot. Can y'all hear me?
Yes, sir. We can hear you loud and clear.
I'm sorry. I'm not very tech savvy. No, I just wanted to comment. We visited with Harley. Just kind of give y'all an update. We have our stormwater permit back in compliance. And one of our deals that we've always been in challenge with is dealing with the culture of the people that we have. And so I brought in a guy named Brandon Sides. Brandon's come into here and he's kind of taken over the operations and the TCEQ issues with it. We have, we've reached out to the ladies, the investigators out of our Abilene district office. They're new. I think if this happened back in 2022. And so when this came to my attention, I really thought this was kind of I thought the issue was settled. And so, but we're going to make it, we're going in, we've let about half of our people go. And we're replacing them with more qualified people who have, our interest in their best interest and for what we're supposed to be doing for y'all. And that's really all I just wanted to comment about and we are in continuance of cleanup. We've got a vast majority of it done. We would like to have a little bit more time, but we are dedicated 100% to getting this project finished and making a culture change so we can prevent this from happening again.
Well, thank you, Mr. Stone, for your comments and glad to hear it.
All right. Was that all I need to do?
Yes, sir. Unless there's something else you want to say.
No, thank you for your time.
Well, no, thank you very much. Appreciate you.
And I'm sorry about that unmute that mic or whatever. So
we're having mic issues here too. So no worries.
Okay. Thanks. Y'all have a blessed day.
You too.
Bye-bye.
Mary, has anyone else signed up on this item?
No one else has signed in on the enforcement docket, so you're ready for OPIC.
Garrett?
Good morning, Chairwoman and Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC has reviewed each of these enforcement items, and with the exception of remanded item 10, we support adoption of all the orders presented by ED staff.
Thank you, Garrett. Colleagues, I've reviewed the backup material for the ED's recommendation, and I'm on board with these appointments. That's wrong. Well, I move that we adopt 7 through 9 and 11 through 22 as recommended today by the executive director.
I second that motion.
All those in favor say aye.
Aye.
The motion passes. Thank you. All right. Shall we go back or shall we go forward?
Well, do you want to take 23, which is the enforcement report, while these folks are up here?
Absolutely.
Item number 23 is the consideration of the monthly enforcement report, and the executive director is available to present this matter.
Good morning again, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. My name is Amy Sedemeyer of the Enforcement Division, and with me are Craig Pritzloff of the Office of Compliance and Enforcement and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2025 through January. There were 421 effective administrative orders issued, and of those, 40 contained supplemental environmental projects. These orders assessed a total of $5,871,616 with a payable amount of $3,576,901. $1,477,296 are to be paid towards supplemental environmental projects. 6,407 notices of violations have been issued through either our field offices or review of self-reported data in our central office, and 663 enforcement action referrals have been received. There are 3,043 pending administrative orders with 1,432 cases that are on the backlog. 125 cases are pending at the Attorney General's office for representation in district court, and 5 judgments have been issued. 1,379 cases are being tracked for compliance. We're available to answer any questions you have.
Thank you so much, Amy. Any questions or comments? Nope. Nope. Do we have anyone signed up on this item?
No one signed in.
Excellent. Garrett?
OPIC has no comment except to say that we appreciate staff's report.
Excellent. I'd like to thank staff very much for the report and the work that they do to ensure compliance. Colleagues, do you have anything else to add?
I'd like to connect the dots from the previous comment we heard from the commenter on the enforcement docket referencing new staff from our agency that they're working with as investigators. And I think that really reflects a lot of the workforce that are captured in the agency's efforts getting reported to us here too. And I just want to acknowledge the tremendous effort and work that our agency is doing behind the scenes, where our new staff coming on, learning the expectations for how this agency conducts business, but also for all of those existing staff who have suddenly become, as present company included, the most experienced person in the room in your respective role. It's a great opportunity, but one that I think puts pressure on our staff in this space. So I'm grateful for their work and their efforts, and seeing continuous progress on the backlog, making progress in spite of that piece.
Katarina?
No, just thank staff for their efforts. Thank you.
Yes, Bobby, well said, as usual. Thank you. No action is required on this item. Ms. Smith, please call the next item.
Would you like, we'll go back to 5.
Let's go back to 5.
Call that one again.
Thank you.
Give everybody a moment to get up here. Item number 5 is the consideration of adoption of the renewal with amendments of TPDES General Permit number TXG 670000, which authorizes the discharge of hydrostatic test water from new vessels that contain raw water, potable water, or elemental gases, or vessels that contain petroleum substances or waste related to petroleum substances. And the executive director's staff is here to present this item.
morning, good morning, Chairwoman and Commissioners.
Is your mic on?
Yes.
Yep,
Does that help?
that helps. Thank you.
Thank you. Good morning. And apologies for my misunderstanding and missing my last call on this general permit item.
It's perfectly fine.
I'm Shannon Gibson with the Water Quality Division, and today I'm requesting adoption of the renewal with amendments of the Texas Pollution Discharge Elimination System General Permit number TXG 670000, which as stated authorizes the discharge of hydrostatic test water from new vessels, vessels which contain raw water, potable water, or elemental gases, or vessels that contain petroleum substances or waste related to petroleum substances. The proposed permit will replace the current general permit when it expires on April 5th, 2025. Public notice of the draft permit was published in the Texas Register and in the Houston Chronicle newspaper on November 8th, 2024. A hybrid virtual and in-person public meeting was held at TCEQ on December 9th, 2024. The meeting was attended by one stakeholder. No formal comments or letters were received or submitted, and the public comment period ended on December 9th, 2024. No public comments were received during the public comment period. Staff recommends adoption of this general permit. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. I'm available for any questions.
Thank you very much. Questions or comments? Mary, has anyone signed up on this item?
No one has signed in on this one.
All right, OPIC, please.
OPIC has reviewed this project, and we note the opportunities provided for stakeholder involvement, EPA review, and public comment. These opportunities resulted in no stakeholder comments, no public comments, and ultimately no objection from EPA. At this time, OPIC supports adoption of the amended and renewed hydrostatic test water general permit.
Thank you very much, Garrett. Colleagues, I've reviewed the backup material about the proposed renewal with amendments on this general permit. I note there were no comments received from stakeholders and no comments received from the public during the comment period. I appreciate staff's thoroughness on this matter and approve moving forward with adoption. Friends, what do we think?
I'm in agreement.
I'm in agreement, but I just had a few comments. I wanted to applaud our staff for the work they're doing, not only for this permit, but also for the other permits that fall under the scope of the somewhat newly delegated authority related to the oil and gas industry. I am proud of our agency staff for their innovation and dedication to getting out permits in a timely manner. And general permits are a great way to streamline processes while following our agency mission to protect the environment. And I appreciate staff's work in updating this permit.
That is very, very well said. I think this commission is very, very proud to lead TCEQ every single day. Do I have a motion?
I move that we adopt the proposed resolution providing for the issuance of renewed and amended TPDES Permit number TXG 67000 as recommended by the Executive Director.
I second the motion.
All those in favor say aye.
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 The motion passes. Thank you. We will continue on to item 6. Give everyone a moment.
And this is the Galveston Bay Council item.
Yes.
Item number 6 is the resolution to fill 27 of 41 membership positions on the Galveston Bay Council, and the executive staff, our director's staff is here to present this item.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Lisa Marshall with the Water Quality Planning Division in the Office of Water. With me today is Marcella Zertucci with the Environmental Law Division and Nicole Hall with the Planning and Implementation section of the Office of Water. We are here today to request your consideration to approve a resolution to fill 27 of the 41 membership positions on the Galveston Bay Council. The Galveston Bay Council is a 41-member advisory body to the Commission whose function is to advise the Commission on the implementation of the Galveston Bay Plan, a comprehensive conservation and management plan for Galveston Bay. Members serve 4-year terms, and the terms are staggered such that approximately half of the terms expire at the same time. The members of the Galveston Bay Council represent a range of interest in accordance with Federal Clean Water Act, Section 320. The Galveston Bay Council is representative of federal, state, and local governments, research and academia, the private sector, and the environmental and citizens groups. The 27 nominees were either selected by the executive director of their respective agency or entity, or his or her delegate, or were solicited and reviewed by the Galveston Bay Council Nominations Committee and submitted to the Galveston Bay Council to determine which nominees to recommend to the commission for consideration. We respectfully request approval of resolution to fill 27 of the 41 membership positions on the Galveston Bay Council. Thank you for your consideration, and we are available to answer questions that you have at this time.
Thank you, Lisa. Do we have any questions? Do we have anyone signed up on this item?
No one signed in.
Garrett?
OPIC supports approval of the resolution as recommended by the ED.
All right. I've reviewed the backup material for the ED's recommendation, and I'm on board with these appointments. I'd like to thank staff for their work in reviewing and compiling this information. I'd also like to thank those who are serving on the Galveston Bay Council for all their work. I know that these are volunteer positions and people have real lives, families, and jobs, and they are taking the time to actually serve their community, and that is a very big deal, and we are very thankful for that. Commissioners, any other thoughts?
Well said. I appreciate the range of different interests and entities represented by this council, and I appreciate that expertise that it brings to bear to our agency in helping discuss these important policy issues. Thank you all.
Commissioner Gonzalez?
Just want to thank the people for their willingness to serve. It's important.
Absolutely. Do we have a motion?
I move that we approve the appointment of the 27 people listed in attachment A of the backup for the terms listed in the same backup to fill the membership positions on the Galveston Bay Council as recommended by the executive director.
A second?
All those in favor say aye.
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 Aye. The motion passes. Thank you very much.
Thank you.
all. Mary, where are we?
I believe we're at 24 through 27 are SIP matters.
Thank you.
Give everybody a chance to change chairs. Okay, items 24 through 27 are the consideration of the adoption of the Dallas-Fort Worth, the Houston, Galveston, Brazoria, and Bexar County Moderate Area Attainment Demonstration SIP revisions for the 2015 8-hour ozone NACs, and the consideration of the adoption of the Dallas-Fort Worth, Houston, Galveston, Brazoria, and Bexar County Moderate Area Reasonable Further Progress SIP revisions for the 2015 8-hour ozone NACs. The executive director's staff is here to present these items.
All right. Good morning, commissioners, general counsel, and public interest counsel. On behalf of the executive director, I'm Allison Stokes with the Air Quality Division. With me today are Donna Huff with the Air Quality Division and Terry Salem with the Environmental Law Division. Additional staff are available online. For your consideration today are items 24 through 28. The executive director's recommended revisions to the state implementation plan to address remaining moderate classification, attainment demonstration, and reasonable further progress requirements for Bexar County, Dallas-Fort Worth, and the Houston, Galveston, Brazoria non-attainment areas for the 2015 8-hour ozone national ambient air quality standard. Staff respectfully request adoption of these SIP revisions. Thank you for your consideration, and we're available for questions.
Thank you so much. Any questions or comments? Nope. Do we have any comments from interested persons? All right.
We do not.
All right. Garrett?
Good morning, Chairwoman, Commissioners, General Counsel, and Executive Director. I'm Eli Martinez with the Office of Public Interest Counsel. For the record, we have followed and reviewed these attainment designation and reasonable further progress SIP revisions, the efforts to engage stakeholders, the public, and interested groups, as well as the comments received and considered in these efforts. And we agree that the public and our Commission's autonomy to craft solutions to air quality concerns in our state will be served by adopting these measures and avoiding going any further down a federal implementation pathway. We further found that the public, interested groups, and stakeholders were appropriately engaged and their comments given due consideration, and we agree with the resolution of those concerns arrived at by the team. For those reasons, we support adoption of items 24 through 28 and are available for any questions. Thank you.
No, thank you very much. A tremendous amount of work goes into these SIPs. I am forever grateful for the staff for all the time that they put in, especially with the extreme time constraints, and very thankful for stakeholders for helping us make these the best possible documents possible. I'm prepared to move forward with them. Commissioners?
I feel the same way. I appreciate your thoughts.
I'm in agreement.
And before we get the motion, I just want to make, I misspoke, and it should, these are 24 through 28. I just said the wrong number.
Okay. Do we have a motion?
I move that we adopt the Houston, Galveston, Brazoria, Galveston, Fort Worth, and Bexar County Moderate Attainment Demonstration State Implementation Plan revisions for the 2015 8-hour ozone national ambient air quality standard and the Dallas-Fort Worth, Houston, Galveston, Brazoria, and Bexar County Moderate Areas Reasonable Further Progress State Implementation Plan revisions for the 2015 8-hour ozone national ambient air quality standard as recommended by the Executive Director.
Do I have a second?
Second.
All those in favor say aye.
Aye.
Aye. Motion passes. Thank you. Right, I believe we're at our public comment session.
That's correct. We're at item 29, the public comment session. The commission will receive comments from the public on any matters within the jurisdiction of the TCEQ in accordance with Texas Water Code, section 5.112, except for pending permit matters or other contested cases. And I just remind everybody that this includes items that were decided today, which are still within the motion for rehearing period. All of these are subject to our ex parte prohibitions, which is found in the Texas Government Code at section 2001-061. And in the interest of time, speakers will be limited to 3 minutes each, with the total time for public comment limited to 1 hour. And I'll begin with our in-person guest first, Miss Annie Spade.
Now we're on. Good. Good morning, commissioners.
Good morning.
My name is Annie Spade. I live at 13508 Trail Driver in northern Hays County. I am a member of CAPE, the Coastal Alliance to Protect Our Environment, and currently enrolled in the Master Naturalist Program. As I've mentioned here before, I'm also active in the global movement to develop localized bioregional sustainability. Recently, I spent 11 days in the Panhandle on Amarillo Creek supporting work to increase recharge flow to the Ogallala. The team was using techniques like beaver dam analogs to enable water to slow and pool for seepage into the aquifer. Water is essential for revitalization, as you know, and I was honored to witness such dedication. Here in Central Texas, I am helping coordinate efforts in my own neighborhood, similarly hoping to regenerate seeps and springs by constructing berms and swales on contour lines to restore our lovely Cambrian Creek. In the 30 years I've lived in the subdivision, this creek has contributed significant flow to Barton Creek, less than 2 miles away, midway on its journey into Austin. Wikipedia notes Barton Creek is surrounded by protected lands that serve as habitat for many indigenous species. This includes Shield Ranch, where underprivileged children have attended immersion camps for 2 decades, swimming in the thus far unsullied stream. Today, both creeks are merely intermittent and most often completely dry in our area. but we citizens are committed to trying to restore them, mitigating our wildfire danger as well. I grew up in Midland. Recently, I mentioned to a colleague how heartbreaking it was to drive through for my 50th high school reunion and see the devastation there. He said to me, yeah, that area has just been sacrificed. I don't know anything you could do for it. Sacrificed. That word hit me hard. My father supported our family as an oil company executive, and there can be no doubt those fuels made of fossilized life forms have allowed us to provide wealth for ourselves. But we know better now. We have technologies to carefully protect our land, air, and water from damage. Methods like infrared imaging and fence line detection to ensure careful monitoring. And we know what industries are unsustainable choices. Plastics need no longer be made from fossil fuels, and plants already producing oil-based plastic can be made to ensure that zero pre-production material enters the Gulf. Considering all that is already happening in our beloved coastal bend and all that continues to be proposed there, it could easily become another sacrifice. Thank you again for your efforts on our behalf and for this opportunity to speak.
Thank you, Ms. Spade. Ms. Spade, I would love to know more about the underprivileged camps that you referenced.
Yes, so they've been, Shield Ranch has had a program where the children that qualified for the free lunch program would come out and spend 2 weeks in the summer, and this was intense. They've since built some cabins, but the cabins are only solar and have ceiling fans. They have no central. It's wonderful if you can ever go out to Shield Ranch. They have beautiful facilities, and they hand carried the construction materials in there so they did not disturb their 6,000 acre protected land. So
how lovely for those children.
Yes, yes. And most of them asked, they eventually developed a program where they would have counselors that the older children that had graduated would come back. And it's just wonderful what they're doing out there, the Shield and Ayers family. Yeah.
That's fantastic. Thank you so much for your comments.
Thank you for your interest.
Mr. Errol Summerlin, he's online.
Mr. Summerlin, can you hear us?
Yes, can you hear me?
We can hear you, Mr. Summerlin.
All right. Well, good morning, commissioners. My name is Errol Summerlin. I lived in Portland, Texas for 40 years, but have now relocated to Maryland for family medical reasons. I'm also a co-founder of CAPE. I had to revise my comments after I heard your discussion this morning, and I'm having a difficult time restraining my anger right now. I'm shaking with disdain for this commission. I have a question. Chairwoman Polk, you already participate as chairwoman of the Texas Board Development Board, in which you voted to fund the building of the Inner Harbor project. Why are you now allowed to participate in a proceeding that decides whether a permit should be granted to build that facility? Couple that with your statement to the House committee that TCEQ would not stand in the way of Texas economic prosperity. The bias of the chair is clear. The decision you rendered today on item 4 will go down as the most egregious decision ever issued by this commission. Hillcrest residents just wanted their day in court, and you denied them that right to due process. This facility will be in their face. 3 blocks from the home of Reverend Williams. 3,000 workers will go in and out of the neighborhood. They fish in the very waters where the discharge.
Mr. Summerlin, I'm sorry to interrupt.
How can they not?
As I mentioned before, this is still a contested matter, and so can't be talking about this during the public comment session. If you have other remarks.
Wait. Let me ask you something. You stated that you allowed legislators, senators, to come and engage in ex parte communications with you today. How can you not grant me that same opportunity? These state reps and local leaders are putting Texas economic prosperity on the backs of this neighborhood when this facility
Mr.
will
Summerlin,
provide
if you
only a
have
drop.
comments on another item, please make them. Or if you have comments of a general nature on a policy matter, please make them. If you don't, we'll move along to the next commenter.
All right. You're going to deny me that right that you gave to the senators, right? So let me tell you about OPIC's role in the public interest, okay? In order to determine the nature and extent of public interest, the Public Interest Council considers the following factors before deciding to represent the public interest as a party: the extent to which the action may impact human health, impact environmental quality, impact the use and enjoyment of property, impact the general populace as a whole, rather than the impact of an individual private interest. The extent and significance of interest expressed in public comment received by the commission regarding the action. All of these were taken into consideration in OPIC's recommendation to grant a contested case. How can you disregard the interest that the OPIC has in protecting this neighborhood? I'm at a loss. I cannot understand this decision. And I guess, you know, the pressure that you felt in this case was just overwhelming, I guess. You didn't have a backbone. At least OPIC has a backbone. That's all I've got to say. Thank you.
All right, we'll move to the next commenter, please.
And that's Ms. Kathy Fulton, also virtual.
Ms. Fulton, are you there?
Yes, ma'am, I am. Can you hear me okay?
Yes, we can, ma'am.
My name is Kathy Fulton. I live in Port Aransas, Texas. I too am Errol Summerlin made some comments that apparently I can't make. But I too am very, very disgusted and upset with what happened on that agenda item today.
And again,
before you stop me,
no,
I can express how I feel. I can express how I feel about it. I'm not making a direct comment on what happened. I'm just letting you know, because you're there as a group of people, as a commission, to ensure that certain directives and laws of your guidance, the guidance for the TCEQ, is being followed. And I know these, I've been keeping up with these meetings for quite some time, as I know Mr. Janicki is aware, ever since some of our hearings a couple of years ago. And so I try to truly stay up on what's going on and what guiding principles TCEQ is supposed to be using. And I just am truly very disappointed and disgusted with what happened today. And I think all of you need to review some of those guiding principles of what constitutes affected people. Thank you very much.
All right, thank you for your comment. Do we have anyone else signed up for public comment?
No, we don't. Would you like me to call the next items?
Yes, please.
Items 30 through 33 are for closed session, and the commission will meet in closed session in room 246 of the Texas Workforce Commission at, I'm going to say 11:15.
Yes, this meeting stands in recess.
The commission met in room 246 of the Texas Workforce Commission for closed session from 11:19 to 12:10 on items 31 and 32 as posted in notice pursuant to Texas Government Code Section 551074. No action was taken. The agenda stands adjourned and the time is 12:15.